My lords and my lady, I'll proceed from where my learned friend Mr. Milima stopped. Permit me, for completeness of record, to say that the second respondent has filed an application dated the 18th of October 2022. We have filed submissions in support of that application, again dated the 18th of October 2022. And we have a replying affidavit sworn by one Samuel Joroge on the 21st of October 2024. My lords, we also have submissions in response to the application seeking conservatory orders dated the 27th of October 2024. And finally, the list and digest of authorities dated 27th of October 2024. I'm reminded by my colleagues that I forgot to mention my name for completeness of record. My name is Eric Gumbo. In understanding the application and the prayers that are currently live before the court, permit me to draw your attention to the application filed by our learned colleagues in the matter 565 for 2024 for just one purpose only. The application has a total of about 13 prayers. The prayer number 1 all the way to prayer number 10 have been spent. In other words, they've been overtaken by events. The last prayer, which perhaps would have been relevant for purpose of understanding what I'm trying to get to, is prayer number 9, which talks about that pending the hearing and determination of a petition, a conservatory order restraining the National Assembly of Kenya from discussing, vetting, voting, and or approving the nomination of a person submitted to the National Assembly made on the 18th of October 2024 by the President of the Republic of Kenya, His Excellency William Samoei Ruto, to fill the vacancy of the office of the Deputy President of the Republic of Kenya. That prayer is equally overtaken by events. The last prayer is for deletion of what they call falsehoods to various persons and institutions. It then follows, my lords and my lady, that the petitioner, His Excellency Rigathi Gachagua, has no prayer that is live before you in relation to the question of conservatory order. Looking at the application number A015, the only prayer that is live before you is prayer number C and prayer number E, both of which deal with the question of swearing in of the second interested party appointed by the President and approved by the National Assembly, they say, from assuming the office of the Deputy President. It then is our submission that the threshold question, the arguability question, the negatory question needs to then address the issue of swearing in. I will then straight go to the issue of swearing in. My lords and my lady, we've spoken to the provisions of Article 145.7. 145.7 very clearly indicates that if at least 2/3 of the members of the Senate vote to uphold any impeachment charge, the President shall cease to hold office. May I add to the submissions that have been made previously that that provision is a self-executing provision. You do not need more. It is not an action of the Senate. It is an action of the Constitution itself. The first question that then we would want to ask ourselves this afternoon is, in light of view of such an express provision of the Constitution, is it tenable that an order of this court would issue to stop it? Let me take as one step further to remind us that at the point at which the deputy president was impeached, he then acquired a constitutional blemish. And we say a constitutional blemish because under the provisions of Article 150, all the charges that were substantiated as against him, including the question of gross violation of the provisions of this Constitution, serious reasons to believe that the deputy president committed a crime under the national or international law, and gross misconduct, then were issues that would be said to have informed his constitutional standing. Now, where am I going with that? I'm trying to make the point that when the Constitution, therefore, has put a dot or a blemish on you, then certainly you become unsuitable to hold office by dint of Chapter 6 of our Constitution. That is, specifically, I would draw your attentions to the provisions of Article 73, Subarticle 1. It says, talks about leadership and integrity, responsibility of leadership. It says, authority assigned to a state officer is a public trust to be exercised in a manner that, 3, brings honor to the nation and dignity of the office. To the extent that those grounds were established under Article 150, it simply means that the person of His Excellency the Deputy President therefore lost the capacity. And why that is important is then, as you consider this question as to whether to grant the conservatory orders or not, would he be one person who would possibly be considered for that situation? And our answer is a simple no. Permit me to speak to the issue of now Article 149. Article 149 reads, within 14 days after vacancy in the office of a deputy president arises, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. First point I would want to make, just to complement what my learned friend Mr. Mudomi has spoken to, as to the justiciability. If the Constitution says that within 14 days of coming into play of Article 145(7), is it practical, is it tenable that within those 14 days, if a party were to have come to court, then going through the hierarchy of the High Court, the Court of Appeal, and the Supreme Court, any dispute touching on that question of nomination would have been resolved? That then speaks to the architecture of our Constitution, to the extent that it is not contemplated that the person who has been impeached would therefore be able to run or even express interest for nomination for purposes of Article 149. Let me then take it one step further to relate Article 149 and 148. In particular, let me start this conversation from one step behind. Our Constitution at Article 1, Subarticle 2, speaks to how our sovereign power is to be exercised. In particular, it says the people may exercise their sovereign power either directly or through their democratically elected representatives. Now, we then relate this to the events of first Article 94, Subarticle 2, which says the role of Parliament shall be, Parliament manifests the diversity of the nation, represents the will of a people, and exercises their sovereignty. What point am I trying to make? A lot of heavy weather has been made about the candidate who has been presented for purposes of approval under this constitution. Now, one of the issues that has been raised is that there was no public participation in relation to the candidature of Professor Kindiki. My lords and my lady, allow me to just take us very quickly to the provisions of Article 149 to provide some bit of context. That within 14 days, allow me to just read it again, within 14 days after a vacancy in the office of a deputy president arises, the president shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days. Vote is the word used. I want to persuade you, my lords and my lady, that the action that the members of the National Assembly would be taking pursuant to this 149.9 flows from the delegated authority under Article 1, Sabbatical 2. It also flows to the role of parliamentarians under Article 94, Sabbatical 2, to exercise the will of the people of Kenya, to exercise their sovereignty. In other words, that is a choice that the National Assembly is making as the representatives of their people. And why that is important is the very question that follows, is when making that decision, is public participation an imperative? Our answer, my lords and my lady, is a straight no. And so that then I give you context. Let me give us what happens in the ordinary elections, and which will be at Article 148. Article 148, Sabbatical 1 reads, each candidate in a presidential election shall nominate a person who is qualified for nomination for election as president as a candidate for deputy president. Then it adds at Sabbatical 2 that for purposes of Clause 1, there shall be no separate nomination process for the deputy president, and Article 137 1D shall not apply to the candidate of the deputy president. What then do we read from that? It means that a simple reading of Article 148, which is what happens in our ordinary elections, does not call for public participation for the position of the nominated person to occupy the office of the deputy president. Now, if we are to agree, and we have seen it in real life, that that is what happens, we don't then subject them to public views around what people think about them, sending memorandum. Once that nomination is done, there is no more that follows other than the declaration after the election itself. Now, why is this important? It is important because of a submission that was made earlier in relation to other provisions of the Constitution which call for public participation. Examples would be in Article 132, for instance, under the functions of a president, Article 132, Sabbatical 2, under the functions of a president, the Constitution says, the president shall nominate and with approval of the National Assembly appoint or may dismiss A, cabinet secretaries, B, attorney general, C, the secretary to the cabinet in accordance with Article 154, and the principal secretaries in accordance with Article 155. It is in that instant that then public participation is called for. So that then when the Constitution talks of approve, it means give an opportunity to the parliamentarians to also interrogate the person that is to be approved for whatever position we have. In this case, it is our submission that the Constitution says vote, meaning elect this person. And the test to be derived from that is first past the poll. In other words, at the point of voting, do the parliamentarians vote to support or a majority of them support the nomination? That is the simple question that could be presented before you for determination. Permit me then to move on to speak to the place of public interest in relation to this process. Now, it would be expected that pursuant to the provisions of Article 146(2), that when a vacancy occurs in the office of the president, the deputy president shall assume office as president for the remainder of the term of the president. Number 2, that is Article 2B, that if the office of deputy president is vacant or the deputy president is unable to assume the office of a president, the Speaker of the National Assembly shall act as the president, and an election to the office of the president shall be held within 60 days after the vacancy arose in the office of the president. What is the public interest question? The public interest question is, it is expected, it is a legitimate expectation by the people of Kenya that they'll have a president. In the absence of a president, they will have a deputy president. In the absence of a deputy president, that will have a situation where the speaker would be able to steer the country into an election. The public interest question that we want to ask or present to the court, would it be in the interest of, now that it is clear that there is no occupant of the office of a deputy president, would it be in the interest of the public to expect or to push the country to a potential election under this article because we want to issue orders that would stay the filling of that office? In our understanding, Melauts and Meledi, that would be pushing the Constitution a little too far. It should not be lost on us that this same petitioner, the mover of this very petition, during the discussions around the motion itself, we had terms like kufa dereva, kufa makanga. What stops him from filing yet another impeachment motion against His Excellency the President tomorrow? It shall be processed. If it is processed, we'll have walked straight into a constitutional crisis. Now, that militates against public interest. And we're saying crisis because we live in this country, and we know that as a matter of fact, we do not have a duly constituted electoral commission. Even if it was the case that we have a deputy president as of today, then pursuant to the provisions of, again, Article 134, which speaks to temporary incumbency, such person would not be able to appoint the electoral commission. What then does that mean? It means potentially that the first person to get to Uhuru Park and get sworn will be the president. Melauts and Meledi, is that a position we would want to allow the country to get into? Permit me to add by saying this, that these constitutional principles are exercised within a particular context. It is a political context. Political context by its own nature, and I had my learned friends speak to the fact that we live in a constitutional democracy, is a competition. In that competition, there will be those who will be for one party and those who will be for the other party. Naturally, it follows that when one party loses office, there will be some measure of discomfort. What then does the court do? It is in those occasions that the court rises to steer the country through that process, so that then the competing interests are balanced in a way that ensures the stability of the country. And because they're deep, it's very interesting and very, something to be very proud about to be Kenyans today, that we are talking about such sensitive issues in this sort of a civil environment. Melauts and Meledi, in other places, when we talk about this sort of transitions, these are constitutional transitions, they end up subjecting the populace to more difficult positions. Now, because we have this opportunity, what then would the court be considering in whether to grant the orders that have been sought or not? Melauts and Meledi, the constitutionalism speaks to something we call utilitarianism. Utilitarianism dictates that the court helps maintain what I would call constitutional homeostasis. That means that we then ensure that whatever decision we take is such as to ensure that there is stability within the country and that the country is given an opportunity to move on. Melons and Melody, these are jurisprudential discussions that have found favor with those who have been there before us. We've been told in our learning of jurisprudence about Jeremy Bentham, about Arthur Stuart Mill. They were great proponents of utilitarianism as a concept of constitutionalism. May I also invite you to the works and findings of Roscoe Pound, who postulates that the law is supposed to be a tool of social engineering, and that then in its implementation, that social engineering is supposed to help to bring stability within the nation. My lords, my lady, it only follows that for us to achieve that stability, then the orders that were issued and that there are ex parte are orders that are supposed to be set aside, the country allowed to move aside. I am most obliged.
Thank you.